Mr. Gennarini.
Chairman McGovern and honorable members, thank you for the opportunity to testify today. CFAM commends the co-chairman of the Tom Lantos Commission and their staff for bringing our attention to the shocking and systematic violations of the rights of women and girls in Afghanistan. We join our colleagues in calling on the U.S. government to make use of all available tools to hold those responsible to account and to bring victims the relief they need. My testimony will address the concept of gender in the context of discussions of a new international treaty on crimes against humanity currently being discussed in the General Assembly's 6th Committee, which is being promoted as a response to the outrageous abuses committed by the Taliban. Because of the seriousness of the topic and the gravity of labeling anyone hostis humani generis, enemy of the human race, I want to urge a strong note of caution against importing the notion of gender as a social construct, sometimes referred to as gender ideology, into the crimes against humanity framework. This pertains to both the established category of crimes against humanity known as gender-based persecution, already enshrined in the Rome Statute of the International Criminal Court in 1998, and the newly proposed category of gender apartheid. When the Nuremberg trials were convened, the concept of crimes against humanity, which was then considered novel and controversial, became essential to bring justice to the victims of the Nazi regime and to hold perpetrators accountable. The basic tenet of the Crimes Against Humanity framework is that there are certain crimes that are so egregious and inhumane as to be always and self-evidently criminal, so that anyone committing such crimes is deserving of punishment, even when the perpetrators act with the backing of the law or under military orders. While the gross violations of human rights perpetrated against women and girls in Afghanistan can indeed rise to the level of a crime against humanity, adopting the concept of gender as a social construct in the context of crimes against humanity presents serious legal challenges that remain unanswered. The concept of gender opens crimes against humanity to novel and dangerous interpretations, including the weaponization of international criminal law against opponents of gender ideology. As a result, anyone who believes that there are real differences between men and women based in biology could be labeled an enemy of humanity and an international criminal. Those calling for a broad definition of the crime of gender apartheid are transparent about their intent to bring about a broader vision of gender justice that goes beyond internationally recognized human rights through an open definition of gender. The Office of the Prosecutor of the International Criminal Court has already adopted a definition of gender as a social construct that varies within societies and from society to society and can change over time. In a policy paper for the purpose of investigating and prosecuting precisely the crime of gender persecution. Under that policy, officials, politicians, religious leaders, and other public figures who do not agree with policies based on gender ideology could be accused of gender persecution. In a similar way, they could be accused of gender apartheid for their contribution to legal regimes that are deemed to institutionalize domination by one gender group over another. This puts a target on religious people around the world who believe in the complementarity of the sexes, including Catholics, Christians of all stripes, Muslims, and Hindus. Indeed, the charge of gender apartheid has been hurled against the Catholic Church because it only allows men to be ordained. Any legal measures that deny or limit the realization of gender ideology in schools, family law, religious spaces, and society more broadly could rise to the level of a crime against humanity, including restrictions on transgender identity change and sports policies, women's-only spaces, protections for parental rights and the conscience of health workers, and even restrictions on access to transgender hormone therapy and surgeries for minors. Using international criminal law to crack down on critics of gender ideology is not as far-fetched as it may seem. It is fully in line with the ongoing campaign by Western countries, and I am sad to report also the U.S. State Department, to silence what they call anti-rights groups. This Orwellian label has been applied to my organization, CFAM, as well as other U.S.-based organizations by UN mandates and organizations funded by the European Union and powerful foundations to silence and isolate views they don't agree with. Adopting gender ideology in the Crimes Against Humanity framework would undermine the goal of prosecuting the most heinous crimes and divert energy and resources to social engineering and even the totalitarian imposition of gender ideology. Gender ideology is first and foremost a theoretical and analytical construct. It is designed for social studies and social engineering. The inevitable effect of introducing gender ideology in the Crimes Against Humanity framework is to call into question every aspect of social, political, and economic life as a potential crime against humanity. This is far from the original motivation for establishing a framework to prosecute crimes against humanity in the first place. It is fundamentally at odds with the principle that crimes against humanity must be self-evident and egregious. It is understandable that well-intentioned individuals and organizations would want to enhance protections for women and girls through the concept of gender apartheid. After all, it seems a powerful rhetorical tool. However, the confusion and indeterminacy that would result in international criminal law from such a doctrine makes it necessary to carefully review such proposals before Congress can lend them support. Our government, our international partners need to work on protecting the rights of women and girls. They must not use the Crimes Against Humanity framework to impose extreme and fringe views about gender and society that have nothing to do with protecting women and girls. Thank you.
In the draft treaty, the fact that the definition of gender has been removed actually provides more space for states to decide what definition is appropriate in their particular context. So rather than sort of forcing a definition, it actually does the opposite.
With regards to what I said about the way gender is already being interpreted in international criminal law, including by the ICC prosecutor, that's all available in the full testimony, including the guidance on gender persecution according to the current definition of gender persecution in the Rome Statute. And so I'm not addressing a fictional concern here about an open definition of gender and how it's being employed in international criminal law. I'm addressing how already the International Criminal Court's prosecutor is targeting social groups, religious groups, based on their beliefs on the complementarity of the sexes or with regards to the actual definition of gender in the Treaty on Crimes Against Humanity, I have to disagree with my colleague from Human Rights Watch. I am a lawyer, and I deal mostly in international human rights law, and lately also in this negotiation on the Treaty on Crimes Against Humanity. And the fact that the Treaty on Crimes Against Humanity removes the definition of gender from the Rome Treaty doesn't just leave an open definition of gender, because the reason the International Law Commission gave for removing the definition of gender was quite elaborate in endorsing an open definition of gender. So the effect of removing the definition of gender from the new Treaty on Crimes Against Humanity would effectively ratify what the ICC prosecutor is doing and applying an open definition of gender as socially constructed in international criminal law. So I think there is a clear danger there about indeterminacy and confusion that undermines the principle of legality. Thank you.
Mr. Mary.